Hello, hi. This is part 2, the second recording of this lecture on intellectual property, where, as I mentioned in part 1, I want to address the two questions of what is IP and why would you want to choose IP, intellectual property, as a subject or option to choose for your undergraduate law degree program. And in part 1 of the recording, we examine what IP is from the context of the syllabus and the 6 main IP rights that exist within the syllabus of the University of London, where we have these 6 main IP rights. And I've given you different examples. Many of them came from real cases concerning how various companies have used these IP rights to protecting their intellectual property. It's not just for companies, but even relevant for individuals. And for part 2 of the recording, what I want to now focus on is why IP, and in particular to addressing a very practical question of how is it like studying IP as a subject from the perspective of a student. What is it that you would want to know about IP as a subject? What are the characteristics of the subject? And eventually now, would it be something you want to do or choose for yourself? And I think the first reason of why you would want to study IP law is that as a subject, and in comparison to really some other subjects, this is one that's modern, it's contemporary, it's on a cutting edge, it's developing. For many reasons, take one as one example, and this is in relation now to this buzzword, this current theme that we are seeing regularly in relation to how is it that our privacy is protected. You may be aware of the new regulation called the GDPR, or a while back the PDPA. These are all regulations that protects privacy, the personal data of individuals. And so you find that this is a topic that we also touch on briefly within intellectual property, where what has happened is that in order for law to catch up, in order for law to ensure there's an adequate response to the pervasive infringement of individuals' privacy, what has happened is that IP law has evolved, and that used the law of confidential information, which I explained briefly in part 1 of the recording, where they now treat privacy to be protectable within the laws of confidential information. Now, you must appreciate that this development took place even before, for example, the GDPR or PDPA. It's an evolution of privacy laws. And I want to use this as an example to show how that the subject or the study of IP is not just dealing with things that we protect last time, but rather things that we protect now, and how the laws have changed, how the laws have modernized to develop to suit modern needs. And IP is really, in the instance or in the context of the laws of confidential information, it has evolved to ensure that it can cope with this new protection that we all want, and that is on protection of privacy. Another example of what I mean by modern is, as you can see now in this particular diagram, of how we can use trademark not just to protecting a name or logo or slogan, but we can use trademark to protecting even the shape of a chocolate. I'm not referring to the name of Toblerone or Kit Kat. I'm referring to the shape. Toblerone has successfully applied for a trademark over the shape of their chocolate, the triangular shaped chocolate. Kit Kat tried recently, but failed. Now, of course, for purpose of this recording, I won't go into details of why it was successful or why it failed, but the point is that laws are catching up. Laws are developing. Laws are contemporary in that we now recognize that companies don't want to only use trademark to protecting their name or logo, but rather protecting various different aspects of their mark which they use in trade. That mark could be a color, and I talked about Tiffany for example. That mark could be a slogan, as Nike, maybe as an example, or in this instance now, a shape. Not just that. In fact, what we'll cover eventually in our syllabus is to examine whether can trademark be used to protecting a smell, for instance. If I ask you right now to think of a very famous smell that is distinctive to a company, that you associate that mark to be what is being used in that trade, in that company, what smell would come to mind? And maybe you think of this famous company of Famous Amos, a worldwide company that sells chocolate chip cookies. And so Famous Amos, it's a very distinctive smell. You walk past the stall or shop, you smell the nice, flavorful, fragrant chocolate chip cookie smell. And even from afar, without having to look up, without looking at the word Famous Amos, you know that that is a smell from the company. Now, so the question is this: can Famous Amos trademark that smell of chocolate chip cookies? This is one example of what I mean when I say that IP is a subject that's contemporary, that's modern. We are developing, and we have seen successful developments of intellectual property in various aspects. In my example now, that of trademark law, in protecting different new business aspects. Now, the other reason as to why you want to study IP as a subject, number two, is that it's interesting, it's exciting. Perhaps in some of my earlier examples, where we talked about Toblerone, Kit Kat, Famous Amos, or in part 1's recording, we talked about Nike, Adidas. All these are obviously something very relatable that we are able to follow, and that makes that subject more interesting. You are not studying something that you only read about in law textbooks. You are actually studying a subject for which you are reading about in the papers. You are studying cases of which these are companies that you buy products from. And so that makes it to be a very interesting subject, and that's, I think, good as a reason for why you want to choose an option paper, because it helps you to relate better to the subject matter, it helps you to memorize cases better, helps you to enjoy the subject matter, and it's really important as considerations of why or how you choose option papers. One example right now of what I mean by interesting or exciting is, of course, in the area of celebrity endorsement. Now, I've no doubt that in this instance, Jackie Chan, for instance, is lawfully and with consent where he is promoting a particular product, and so there's no infringement of any law. But using this as an example, what if someone were to take his photograph, take his picture, which today with Photoshop, not too difficult, and so someone were to take his picture and to use it on another product or service. Now, if someone has misused or used another person's image, what law can you use to sue? Or maybe it might not be the image, it could be perhaps his voice. And I think that if you were to imagine how his voice sounds like, some of you may know how that is. It's fairly recognizable. And so what if now this is a radio advertisement, and you hear Jackie Chan's voice promoting a particular service or product, and you may think, oh, this celebrity, Jackie Chan, is endorsing this product, it could be good, and you might be influenced to try the product. And so now, of course, if it is Jackie Chan's voice and it's really him, it's fine, no issues. But what if it is not? And so I am referring to or discussing with you right now the topic of false celebrity endorsement. Now, what law can we use? what law would you think we can use to protecting such false celebrity endorsements? If you were to recall or go back to the earlier part 1 recording, I listed 6 different IP rights. Which IP right would you think can be used to protecting situations like this, where another competitor takes your image, takes your voice, and promote and sell its product? Maybe even not your voice, maybe not your image, but what about if I were to take your signature? And so here is where I may spell out or write out Jackie Chan, and the fact is maybe my name is Jackie Chan, and I use that signing or that signature now to be signed off on products, on packaging, and I mislead or misrepresent the public to make them think as if it is that real celebrity endorsing that product when it is not. So what law can we use? And that is the law of the tort of passing off. And so what you are seeing, therefore, as I'm trying to explain to you about IP and why you should choose it as a subject, is that it deals with such kinds of interesting, exciting, relatable kind of topics where the laws are there to ensure that it's able to protect businesses. And all these are situations that we can relate to, and hence making IP as a subject that we can study fairly easily. The third reason why IP is a good option paper, and as from all my early examples, is that it's extremely relevant and business oriented. Relevant not just for a business, but even to us as an individual. Again, Adidas as an example. Have you bought shoes from Adidas? And so what if now you have bought shoes, but you had bought the wrong one? You bought the shoes that actually were manufactured or under the brand name of Payless. And so what happened was this, and this is a real case, where this other company, Payless, had actually manufactured shoes, where as you can compare and look at the picture on the screen, it had used Adidas's 3-stripe logo. But they were smart. They did not use 3 stripes. They used 4 stripes, 5 stripes, basically stripes, to sell their shoes. There were some shoes that were only with 2 stripes. And so it's not exactly the same as Adidas. And so, of course, Adidas sued them for trademark infringement. And of course, passing off is also relevant. And that's my point, in that when I say that it's a subject is relevant, because these are products that we buy. And so hence it's of relevance to us. What rights do we have as a consumer or customer when we see these kinds of situations? And for sure, from the business perspective, it may be that you are an importer and you have bought products like that, and it's now untrue. It's not really from the real brand. Or it could be where you are the business and you are Adidas. What are your rights? And so if you are in business, if you are doing trading, if you are a marketing person, I think IP is really a subject that's extremely relevant to you. In fact, in my earlier part 1 recording, I talked about how, for instance, a marketing person may design a brochure. So surely we want to protect that design of our brochure, the words that we use, the way we write that brochure, the drawings that we may have used, the photographs that we could have used. And all this comes under the protection of intellectual property, the subject of copyright. And so it's relevant. The next reason, number 4, and that is insofar as the exam format is concerned, for those who are registered on the University of London's law program and they want to choose IP, here would be the topics and a breakdown of the questions. And as you can see now, there are in total 9 questions, 1 for confidential information, 2 for copyright. And copyright has 2 because every year, more or less, there'll be one question problem and the other essay. Then one question from design right, and then 2 again from trademark, one problem, one essay. Passing off might have 1, but it's not there every year, so I put that in the brackets. And patents, also 2 questions, one essay, one problem. And there's still a final question, which is there. This is question 1 every year, which is a very general essay question. Sometimes it may contain or carry with it the theme dealing with unfair competition, asking the question of whether or not are our current intellectual property laws sufficient to prevent unfair competition. If someone were to misrepresent, if someone were to misuse my trademark, are the current laws adequate or satisfactory? Or should we now perhaps have more laws to ensure that such kinds of unfair competition does not take place? And so that's all this critical evaluation. It's an essay question. And so in total now there are 9 questions, and that is correct. IP is one of the few or rare subjects where it has 9 questions. There are some years with 8, but usually 9 questions, and you answer 4 out of 9 within 3 hours. And so for that reason, maybe if you ask me, IP is a good subject from the exam point of view because they give you more choices to choose from and to answer only the same 4 questions. But really, when I say it's exam friendly, what I meant would be in relation to the topics which I have put in bold. And you see and observe carefully, and I think you know what I'm trying to get at. Why I say that IP is a good option paper, why I say that it's exam friendly, is that if you were to choose, say for example now, copyright, and you find that just by choosing copyright, you would already have 2 possible questions that you can attempt. And trademark, another 2. And all you are required to do in exams would be attempt 4. In other words, any 2 areas between copyright, trademark, passing off, you are guaranteed of having 4 questions with in fact 2 backups. If you want to take a risk, just do 2 topics. Say copyright, trademark, 4 questions. Or trademark, patent, 4 questions. And so you find that this is a subject where it literally allows you to spot topics exclusively, leaving out the other things. And yet you will be able to have 4 questions. Obviously, this does mean that you would now have to attempt the essay question, because if you choose copyright and trademark, 4 questions, they will be 2 problem and 2 essay. But IP is a level 6 subject. Many of you are in your final year of your law degree program. You ought to be able to answer essay questions. In fact, by now you may have realized this, that actually overall it's better to attempt essay questions than problem for at least 2 reasons. The first reason is that essay questions allow for a student to show off, allow them to write a really good answer and therefore score or do better in that question or in that subject. Whereas if it's a problem question, the answers really from many other students are of fairly similar standards. You put down a similar or the same cases. Your application of the law to the problem question is pretty similar, and therefore the marks you get are all pretty similar. But essay questions allow you to score because you can be critical. You could have been widely read up. You could have a particular thought on a particular point. You may analyze a case with a different interpretation. And all these that you write out in exams allow you and your answer to be different and to score. So that's one reason why essay is good. The other reason, quickly, is the fact that essay questions just takes you 2 seconds, 5 seconds to read that question and you know what they are asking you. Whereas, let's take, say, for example, now the commercial law paper or the contract law paper in the past, and the question itself has got like half a page, 15 lines, and you have to read everything to understand and not miss out any facts because the facts are important. And so reading the question itself takes time. Then you would very often be rereading the question, isn't it? One more time or a few more times as you write your answer to refer to the facts, to make sure you understand correctly, to make sure that you've addressed all the issues. And in fact, it's not uncommon that students fail to read carefully, miss out facts, or they misconstrue or misunderstand the facts. And so problem questions are dangerous perhaps in that regard, hence making essay questions better. And I'm saying this because IP is a level 6 subject and you are a level 6 student, a final year law student, and you ought to be able to cope and be comfortable with such questions. And in fact, for IP, if you were to choose essay questions, it's good because why? As I'm trying to show to you now, that then you can choose just 2 topics: copyright, trademark, or trademark, patents, and you have 4 questions. Right, so that's a 4th reason why IP is a good subject. Number 5 is that it's a subject that we regard as quote-unquote a passing subject. And when I say that it's a passing subject, I know it's very subjective in that regard, because obviously it depends on whether you had studied or put in effort for the subject, as well as the fact that whilst your friend may pass, that may not mean that you would pass. But still, let's look at the statistics or the data given to us by the University of London. And here would be the global pass rates with a comparison of the Malaysia and Singapore pass rates. And I use Malaysia because we are operating in Malaysia and Singapore. We teach in those countries. And so it's useful for me now to examine the Malaysian pass rates to compare the kind of contribution that we could provide to students choosing this subject. And you have spotted it. IP enjoys an 84% pass rate, which if you compare now to, say, the bottom one, criminal law, it is 21% higher. So if you have passed crime, public, contract, LSM, all these year 1 subjects have a far lesser pass rates, right? And so if you had passed those year 1 subjects, you will pass intellectual property. And so not just pass, 84% of students in Malaysia and Singapore pass. And it's way higher, at least about 10% higher than the global pass rate. And so I want to assure you that with the right support, intellectual property is not that difficult. It enjoys a high pass rate. Now, no doubt, it may not be the best subject for passing, but still, if you compare IP with the top global pass rate subject, jurisprudence, the first subject that stands at 90% pass rate is extremely good, but still, if you compare now with the pass rate that we have for IP in Malaysia and Singapore, it's 84%. So 84% pass rate for our students compared to 90% global pass rate. To be honest, the difference is not so significant. In my opinion, it is still a fairly good indication of the pass rate that's good in comparison, particularly now to the lower end subjects of crime, public, and contract. And so that's, of course, the pass rates for Malaysia and Singapore. And if you are a Hong Kong student, I know you want to ask me this, and that is in relation now to what about Hong Kong? Of course, some of you could be listening to this lecture and you may be from other countries. I will leave it up to you to find out what those pass rates are. If you need assistance, and if I have the data, please do PM me and I can provide you with the information if I have it concerning statistics and data of your particular country. For example, I am aware that there are some of you who might be from Sri Lanka, and so if you want to know the data, please do contact me. Otherwise, let's look at now Hong Kong, and you'll find here that the pass rate for Hong Kong, to be honest, is not fantastic. It is at 57%, and the global pass rate, of course, stands still at 75. So I suppose this might be of concern to you because you can clearly see how it's not fantastic. In fact, it is it is the second lowest pass rate subject. The lowest, of course, being LSM, surprisingly, at 53%. And then IP in Hong Kong, it's at 57. Whereas even commercial law, which is this other subject which I teach on, it's at 81%, right? Hong Kong pass rate. So IP is, I suppose, if you look at the data here, not so pleasant, a bit disturbing. But of course, we know why. That's because we don't provide IP classes in Hong Kong, or at least I don't teach IP in Hong Kong, where we don't provide face-to-face teaching, whereas we do in Malaysia and Singapore. And so really, I suppose if there's any takeaway point from these data is that whilst IP is a passing subject, and even 57% is of a pass above 50% pass rate, but I think it's great or good if you are able to find some support to teach you on a program the way we do in Malaysia, Singapore, because the pass rates as a result is significantly higher. Now, apart from pass rate, a very frequent question I get, of course, would be this other question. What about scoring? Beyond just getting 40 marks to pass, can I do well? What is the highest mark that IP has produced? And so in this next slide, which is again a data compiled from URL, from 2010 all the way to 2011, all the way to 2017, the examinations last year, May, this would represent the highest mark awarded for each subject for the past 6-7 years. And so IP, for example, not fantastic, but not too bad in that consistently we are able to see students obtaining a distinction. So 70 marks is a distinction, it's an A, it's a first class mark. And last year, for example, the highest mark awarded in the world, so this is not just a comparison of Malaysia, Singapore, Hong Kong, it's by world standards. And so for IP last year, the highest mark was 70, as with the previous year, 2016. No doubt, there were some years where we did not get a distinction, but most years we did, or rather IP, right, managed to have students who had obtained 70 and above. And so this gives you a rough idea of the highest mark awarded for intellectual property, right, for this subject. If you take a quick glance, to be honest, IP is not really a subject that has produced too many distinctions. And even their distinction at the highest end is just 73 marks in the year 2014. Whereas if you look at, say, subjects like jurisprudence, you look at subjects like, for example, commercial law even, the distinctions are of a much higher quality. So you take commercial law, where in the year 2015, it was 78 marks. You look at jurisprudence, in the year 2017, last year, it was a range of 80 to 84 marks. And so you are seeing how other subjects has produced also very good marks. IP in comparison is just average. But that is if you're looking at getting a distinction. If you are aiming to pass, as showed you earlier on, right, the pass rates are pretty high. It's really what I described to be a passing subject. And if you can pass your year 1 subjects, you can pass IP. And this is the main thing which I want to share with you, to giving you an assurance that IP is a subject that is not just manageable, but for which you can pass. The final reason for why you want to choose IP is that there are ample available research that you can get online. You will not be at a loss, not knowing what to study or what to read, and you can find articles available online. Just key in certain keywords and you will get the relevant hits. And it's really great because why? It provides you with support for you to understand the law better and various different viewpoints to make your understanding more enriched and being able to answer even the essay questions. Now, however, of course, I want to be objective and now provide you with several reasons as to perhaps why IP might not be a subject that you want to consider. And so here now in this slide talks about 4 reasons where IP perhaps might not be a good option. It's bulky. I teach contract, commercial, IP, succession, and I've also taught on some other subjects previously. And I'm telling you that from my experience, intellectual property is bulky. And so you would want to be aware of this. So I don't want to just tell you how it is a good option paper. Although I think it is, I think you need to be given the correct information. And so this slide will, in a way, allow you to appreciate IP in a more deeper sense for you of whether you want to choose this as a subject or not. IP is sometimes perceived to be technical. There are some individuals who don't like the subject because they feel that it's technical. In my opinion, it's not really so. In fact, from the topics I've explained earlier on, from the examples and cases that we have seen, I think it's really a very relatable subject. IP is a subject that is heavily influenced by EU case laws. And so that might not really be a very good point, but still at a very small level, because what I'm trying to say is that because of its EU influence, you end up having to remember or memorize EU cases. And if you have seen EU cases, you know that these are cases that are long, their names are long, difficult to memorize or to even spell or pronounce. And so that's a bummer, and that might be a turn off for some of you. Notwithstanding Brexit, in case you're wondering, well, David, with Brexit, must we still know these case laws? The answer is yes, because a large part of the UK IP system or regime is influenced and taken from the EU directives. And so because of that, EU law will continue to be prevalent and influential to have a strong bearing on how the UK courts would interpret those provisions that are equivalent with the EU directives within the UK. The last reason of why you might not want to choose IP is the fact that it's a subject with a very specific theme, and therefore the type or nature of the subject might not be something that appeals to you. And so this is really very subjective. It may be that as I go through these 2 recordings, the last one and this current recording, that you find that you enjoy the subject, that you like it, that you find it interesting. But it may be that for some of you, some others, you think otherwise. And so I recognize that, and I think that therefore this perhaps may be the one singular reason or factor that you would want to think carefully over whether is this a subject that appeals to you, that you enjoy, because if you don't enjoy this kind of subject, then you should choose other option papers. So in summary, in one final slide now, just to show you why you would want to study IP as a subject. On one hand now, we have these 6 reasons which I've explained as to why IP is a perhaps good subject. And over here now, 4 reasons as to why it may not be a good subject. Please take note that I'm not trying to suggest to you that there are 6 reasons over 4 reasons against, and therefore 6 wins over 4, so choose IP. No, I'm not saying that. Rather, what I want you to see is that there are these characteristics that define IP as a subject. And it may be that these reasons for IP could be appealing to you and to override or to overcome the 4 reasons against, and then you choose IP. But it might be that for some of you that you place particular weightage on certain factors. Maybe 0.7, bulky. You could be a busy professional. It could be that you are lazy. It could be you have just no time to study or read. And therefore, you might not want to choose IP because, as I'm now saying to you, it is bulky as a subject. And so 0.7 itself, the bulk of the content of this course, may be of significant weightage, to the point that based on this one point may allow you to choose or to decide that you do not want to choose this as an option paper. And so it's subjective, it is to each individual. As a further summary, I want to just look at IP law from this angle of who are the people who perhaps might have an interest in the subject. And no doubt, of course, what comes to mind clearly will be authors, artists, designers, inventors. But I think that it's beyond that. Even as I said in my earlier lecture or recording, a marketing person. Obviously, a businessman, in that you may have confidential information to protect. It may be that you have a trademark to protect. It could be that you have a business idea to patent. And so the entrepreneur, the businessman, may find relevance or interest and importance in studying intellectual property. Or even a blogger. And why I say a blogger? Because if you are on social media and you are blogging, you'll be involved in writing. What if someone were to take your blog and reproduce? It may be that you have used photographs online. Are you sure that you could use those photographs? Could that perhaps now be infringement of someone's copyright? And so what I'm trying to show to you that there are many other professions, a wide range of different people who would find IP to be of interest and relevance. So you need to know who you are, both at a professional level and a personal level, on whether would this be a subject that appeals to you or not. And I think today in the world of social media, that really is a subject that affects all of us, whether we like it or not. And so I regard IP to be a subject that's relevant for someone who wants to protect an idea, as well as from the very basis of the idea itself, right down to the expression of the idea, right down to the eventual commercial exploitation of the idea, where our idea begins now its life as an idea, but ends up as a product, ends up as something for which we could sell commercially. And so many people would find IP to be relevant for this reason. And this slide allows you to see how IP, using its different rights, from the laws of confidential information to design rights, to copyright, to trademark, to patent, allows us to protect our ideas at every stage, all the way right to the end when a product is eventualized and we can monetize or commercially exploit that particular idea. So IP is a subject on this. I mentioned earlier on that social media has really changed how we perceive IP, and that is true because whether we like it or not, we are all involved with the internet. We're all involved in copying and pasting. We are all involved in posting things online, and other people can just take what we have posted. And so both personally and professionally, directly or indirectly, knowingly or otherwise, intellectual property is a subject that we are affected by. I want to end this session by quoting from Alex Kozinski, a famous judge in America. And he says this: "Millions of people toil in the shadow of the law we make, and much of their livelihood is made possible by the existence of intellectual property rights." So I hope that you had benefited from this recording and the earlier one. where we had addressed the questions of what is IP and why IP, and this will help you better decide for yourself whether should you choose IP as a subject to study as part of your LLB program. Thank you very much.